Please the court. Good morning, Your Honors. My name is Michael Ellis.
Hold on. We don't see Mr. Irvin yet. I guess his camera's not on. Are you there, Mr. Irvin?
I can hear you. Can you hear me?
Can hear you.
Okay.
Okay, I can't see you. It's not necessary, it's not necessary that we see you at this point, but I just wanted to let you know we don't see you.
Okay, let me see if I can adjust that. I apologize.
Oh, there you are.
Okay.
All right, no problem. Okay, Mr. Ellis, how about it?
May it please the court. Good morning, Your Honors. Michael Ellis on behalf of Ms. Galvin, the appellant. I'd like to reserve 6 minutes for rebuttal, Your Honor. Broadly, this case is about how dismissal is not a substitute for impeachment, and that's especially true where liability for the underlying accident is undisputed. And for a moment, the trial court did actually understand that it was excessive to dismiss the entire suit with prejudice, using the word on page 1649 of the record, draconian, to refer to its own forthcoming dismissal of the entire suit, also characterizing the dismissal as something that would, quote, kill it all on page 1659 of the record during that hearing below. Nevertheless, the suit was dismissed, and we respectfully request that this court reverse for the following 3 reasons. And we begin where all appeals begin, which is with the standard of review. It's an abuse of discretion standard, yes, but it is a less deferential standard of review for 2 reasons. First, because when the trial court dismisses for fraud on the court, as this court stated in Duarte versus Snap-on, that is an extreme remedy, and therefore there is less deference given to the trial court. The second reason the standard of review is less deferential is that the evidentiary hearing below was not a quintessential evidentiary hearing, not a true evidentiary hearing, and that Ms. Galvin did not testify. And the second reason that this court should reverse is that—
Mr. Ellis?
Yes.
The case was noticed for an evidentiary hearing, correct?
Yes, Your Honor.
Your client was given the opportunity to testify, correct?
Yes, Your Honor.
And she elected not to testify.
Yes, Your Honor. In addition—
Another evidence was admitted, including documents that establish or address the amount of attorney's fees and the related information that would normally be provided to a court for an attorney's fee hearing, correct?
Your Honor, I disagree to the extent attorney's fees were the subject of the hearing below. What was noticed for an evidentiary hearing was the motion to dismiss for fraud on the court. And to the extent the attorney's fees were ancillary to that, I suppose, yes, that was noticed as well.
Let me ask it this way. Were documents admitted into evidence that were of an evidentiary nature?
Over Ms. Galvin's objection? Yes, Your Honor.
Have you raised as an issue on appeal that the trial court erred in admitting those documents?
I would rest on our initial brief to that extent, Your Honor, and my understanding, to answer your question, would be not directly, although indirectly the argument has been raised because we have characterized the evidentiary hearing as not a true evidentiary hearing. When you look at this case—
Well, but what you said a moment ago was it wasn't an evidentiary hearing because your client didn't testify. Your client chose not to testify and had the opportunity to do so.
That is correct, Your Honor. And so that's just one reason that the abuse of discretion is less deferential to the trial court. The other reason is that at the end of the day—
Well, wait, I'm not sure I understand that. It's less deferential because your client didn't testify?
So under this court's decision in Duarte versus Snap-on and also Jacob versus Henderson, where the hearing precipitating the order dismissing the entire claim for fraud on the court is not an evidentiary hearing, the standard of review is less deferential. But even if we eliminate that reason, the standard of review is still less deferential because in this court's decision, again, in Duarte versus Snap-on, where we're reviewing a dismissal for fraud on the court, that's such an extreme remedy that, to use this court's own logic, a more stringent review of the trial court work is done at this level. Not my words. This is Duarte.
What's interesting is the court, as you pointed out, referred to the fact that the court was well aware of the draconian nature of the ruling, and the court then points out that the evidence in this case is certainly more extensive than almost all cases in which dismissal is upheld. And then he goes through in the order preceding that language and leading to the closing paragraph. Brittany Galvin's fraudulent testimony, both in interrogatory responses and in deposition, in conjunction with her thousands of social media posts, interviews, and so forth, sentently set in motion an unconscionable scheme to interfere with the judicial system's ability to adjudicate this matter and unfairly hamper the court's ability to decide this case. So you're not suggesting the court didn't apply the correct standard. You're suggesting that the evidence doesn't support the ruling?
We suggest both. And I think it would be more clear, our argument, if I could get to the second and third reasons we believe reversal is required. And the principal factor here is the fact that liability is undisputed for the underlying incident. That is legally significant under this court's precedent. And again, in Duarte versus Snap-on and also Jacob versus Henderson, this court placed heavy reliance on the fact that liability for the underlying car accident in both cases was undisputed. And
does that preclude a dismissal for fraud on the court?
It precludes dismissing the entire action for fraud on the court, because as we pointed out in the reply brief, and
does any
honestly,
case say that where liability is admitted, but there is, I will rephrase it or phrase it in this way. Let's assume there is absolutely unrefuted evidence of fraud on the court, but liability was admitted. Is there a case that says that dismissal for fraud on the court is not available as a sanction?
Yes. In that case, we briefed in the reply brief. And I want to say, yes, if we look at the holding in Jimenez versus Ortega, there, the plaintiff lied. Assume the plaintiff lied. We accept that as true. That's what the 50 CA determined about the quantity, the amount of damages for lost wages. The 50 CA reversed the order dismissing the entire suit because except the putatively false statements are false, those only pertain to a certain category of damages. Therefore, it was unwarranted, to use the trial court's words, draconian, to dismiss the entire suit. And below the, I'm sorry, Judge Silverman, I see you're.
No, and that was under the facts of that case.
Correct, Your Honor.
And so one of the things I wanted to ask you about is, because you acknowledge you raised this issue in the reply brief, was that argument made in the initial brief?
It's an extension of the arguments made in the initial brief, so that if we look at Duarte versus Snap-on and Jacob v. Henderson, which are our big cases here, those show the general proposition that you cannot dismiss the entire suit for fraud on the court. And then the logical extension of that is, well, what's a lesser remedy? The trial court was curious. What is a lesser remedy? And this is the lesser remedy. When you look at Jimenez versus Ortega and also the fourth DCA's decision in Goga versus Public Supermarkets. Now, I can't say that one is as airtight as Jimenez versus Ortega because the Supreme Court of Florida currently, they took jurisdiction on that case. And so I don't want to place too much reliance on that, but Jimenez versus Ortega is good law in the fifth, and we believe it maps the facts of our case here. And so to answer your question, our reliance on Jimenez versus Ortega is an extension of our arguments based on this court's precedent in Duarte versus Snap-on and also Jacob versus Henderson. And to the facts of our case, the trial court in its order dismissing the entire action for fraud on the court no less than 13 times relied on statements Ms. Galvin made on social media as evidence that she had lied in court. But social media statements cannot amount to fraud on the court. And
what about the affidavit that was filed in federal court?
Yes, the declaration in the COVID litigation, Your Honor.
I think that's the only one that was at issue, wasn't it?
Yes, Your Honor. So Ms. Galvin was only very briefly a member of that litigation. She withdrew from that litigation, and to the extent there are inconsistencies.
Does that excuse statements made under oath in a representation to a court? The fact that she later dropped out of the lawsuit, she didn't withdraw the affidavit saying, "Oh, I'm sorry, it's wrong." The declaration had And my lawyer put it together and it's filled with lies. I really didn't mean to sign that, or I didn't know that's what I was signing.
I'd like to answer that with this court's language from Synergy Contracting Group 2023 case. Direct quote, even lying is insufficient to support a dismissal for fraud, and in many cases may be well managed through cross-examination. Cross her with the declaration. And on redirect, we'll explain in front of the jury, not the judge, that Ms. Galvin withdrew from that litigation, and ultimately that credibility determination is for the jury to make. And this court has
Your client had the opportunity to do exactly that at the hearing, didn't she? And she
Yes.
declined to testify.
and the defense counsel also had the opportunity to ensure that she was deposed or subpoena her or just edgewise ensure that they had confronted her with this information. Instead, as trial counsel for Ms.
But
Galvin,
she was confronted with the information for purposes of assessing attorney's fees. And she didn't choose to present testimony that her statements were misconstrued, they were taken out of context, or even the fact that she says, well, I really didn't remember, I answered as best I could, but here are all my memory problems. And presumably she could have called an expert doctor to say her memory problems are so significant that it is fully understandable why she wouldn't have remembered these things under the stress of a deposition, let's say.
correct, Your Honor. And to the extent there are memory problems, I would emphasize that that's another similarity between this plaintiff, Ms. Galvin, and the plaintiff in Duarte. Both claiming memory problems were the reason for what defense counsel has characterized as putatively false statements. This court reversed in Duarte, and we believe our case maps those facts, and therefore this case should be a reversal as well. And this court more than well, actually, I want to go back to something you mentioned, Your Honor, about the fact that defense counsel did cross her on some of this. On pages 1640 through 42 of the record, trial counsel for Ms. Galvin made a very astute observation that defense counsel had an associate monitoring Ms. Galvin's social media for a long time before some of her testimony was taken. And instead of just confronting her with that information at the deposition squarely to try to refresh her recollection, it got her testimony and then chose to pursue a fraud on the court.
And I'm sorry, was her attorney unable on redirect, or I'm sorry, on examining her at the deposition to bring out that information?
Well, based on the transcript from the evidentiary hearing below, just assume that it's an evidentiary hearing, we don't necessarily know that because defense counsel played video clips of her deposition testimony and then juxtaposed that with other putatively contradictory statements. So yeah, at the deposition originally, there would have been a redirect opportunity.
And at the hearing, the trial court, what you're saying then is the trial court precluded Ms. Galvin from presenting more videos to undermine the presentation by opposing counsel.
Preclude may be a strong word in all candor, but effectively.
Well, counsel, let's talk about candor.
Okay.
You're making an argument that your client didn't have the opportunity to put her case on at this hearing. I haven't quite heard why she wasn't given that opportunity or that she was denied that opportunity. In fact, the trial court specifically asked, does your client want to testify? And what was the answer to that?
The answer was no. And
was your client able to offer other evidence, but was denied the opportunity?
No, but Your Honor, our argument is not that she was precluded from presenting her case. Our argument is that the defense counsel did not prevent clear and convincing evidence that they proved their case. They presented a PowerPoint presentation, which in their own words was nothing new. It merely summarized the evidence already presented. They characterize it that way below and on appeal on page 28 of their answer brief. They have not met their burden. We're not necessarily arguing that Ms. Galvin was precluded from presenting her case because it's not her case to present. It's their job to prove fraud on the court. They didn't do it, not based on this court's precedent in Duarte versus Snap-on, as well as Jacob versus Henderson. And I would also emphasize that this court has been at the forefront of recognizing that the standard articulated in Cox v. Burke is something to be used sparingly. In 2003, just 5 years after Cox v. Burke was decided, in Ruiz versus City of Orlando, the 5th DCA said, despite the painstaking lengths that we went to characterize this motion to dismiss for fraud on the court vehicle we've created, we had, quote, underestimated the seductive power of that remedy.
And Mr. Ellis, I'll give you a heads up that you're into your rebuttal time.
Yes, Your Honor. I'd like to reserve the rest of my time for rebuttal.
Okay. All right, Mr. Irvin.
Thank you. May it please the court, Richard Irvin, on behalf of Sumner Advanced Stores Company, DBA Advanced Auto Parts. This is one of those cases where dismissal is warranted, and we understand that it's a severe remedy. However, when you take a look at the record, when you take a look at all the evidence that was submitted at the evidentiary hearing, it just becomes so much that there's just no way that we can properly defend this case with all these lies, omissions, misleading statements, misrepresentations. And on top of that, there's just no way that the judge could allow Miss Galvin to testify at trial, because doing so, she would have to perjure herself. So based on those two reasons, it's clear that the sanction of dismissal was warranted. I just wanted to go back and briefly address the standard of review in this case, because I think there's some confusion on the appellant's part about what that standard is. This is not a cold case review, because the trial court did hold an evidentiary hearing. In fact, the trial court admitted into evidence all of defendants' exhibits that were attached to the motion for sanctions. There were a total of 65 exhibits, and those exhibits can be found in the record at pages 155 through 862, 1007 through 1065, and 1294 through 1335. After the court entered those exhibits, the court then gave plaintiff the opportunity to testify, but as the court recognized, she refused to do so. And it's pretty clear why she refused to do so, because doing so, she would have to perjure herself. When you take a look at the affidavit from the federal case, she makes representations in there that are completely different and opposite of the representations that she made under oath in her deposition and also in her interrogatory answers. So the trial court did hold an evidentiary hearing, and because the court did hold an evidentiary hearing, the standard of review is abuse of discretion, and there's a heightened component to that, a heightened, clear, and convincing evidence standard regarding the allegations or the findings regarding fraud. And that comes out of Howard versus Risch, 959 Southern 2nd 308. So second DCA case, 2007. Also, I think it's important to point out that the evidence presented need not show that the scheme to defraud was successful. Instead, the issue is whether or not there was an intent to defraud or hamper an opposing party's defense. It's the intent to mislead, the intent to omit information or misrepresent the facts that what matters. Turning to the merits, the plaintiff argues that dismissal is an unreasonable sanction, given that plaintiff disclosed some of her prior medical issues and because defendants had her medical records. But that argument was squarely rejected by this court in Morgan versus Campbell. And this case is much like the Morgan case. And there, what happened was that the wife claimed she forgot that a chiropractor extensively treated her neck and lower back. However, the medical record showed that a chiropractor had treated the wife 16 times between June 1992 and August 1995, based on her complaints of neck and low back pain. So this issue was directly related to the central issue in the case, whether or not the accident in question caused her neck and low back injuries. The trial court found her explanations for discrepancies were not credible, similar to this case. And the extensive and ongoing treatments reflected in the records contradicted her contention that she forgot the chiropractor had treated her neck pain for several years after the accident. So going back to what opposing counsel was saying about the memory issues here, clearly those memory problems that she claims that she has is the reasons why she could not remember all these complaints of pain and treatments and medical records and so forth. It's just not credible when you consider that she gave all these podcast interviews and stating in those interviews in painstaking detail every single condition that she had relating to her reaction to the COVID vaccine. So when you compare those podcast interviews to what she provided here in this case in her deposition testimony, it's just clearly it's not credible that she had these memory issues as the reason why she could not tell the truth. Also, as to plaintiff's claims that we were provided the medical records or that all of her conditions are contained in the medical records, that doesn't give the plaintiff the right to lie under oath. And that issue has been addressed by this court in ICMFG and Associates versus Baird Board Group, it's 238 Southern 3rd 326, 2017 case, where this court observed that just because the defense counsel discovers the truth does not excuse the appellant's conduct or diminish its seriousness of lying. So that case recognizes that a plaintiff does not have to be successful in their attempt to hide the truth, rather than what matters, as I explained before, is whether or not they intended to defraud the court or hamper the opposing party's ability to tell the truth, discover the truth, excuse me. But even if the court were to entertain opposing counsel's argument in that regard, his argument still fails because appellant didn't disclose all of her medical records. She unilaterally chose to produce some records, and then specifically relating to some parts of the accident, but then she refused to produce other records which were clearly relevant to the issues at the case of bar pertaining to her COVID injuries or her reaction to those vaccine injuries. So the fact that she wouldn't produce those records, that squarely hampered our defense of the case. Appellant also contends that her misrepresentations and omissions were a result of her memory lapse, in which I went into already, and that's just not believable given her long history of neck and back issues. So the issue for the court to consider is found in the Ramsey case. And the Ramsey case, it gave us guidance there. It says that in assessing whether or not dismissal is appropriate, the court looked to three primary factors. Number one, whether or not the representations and omissions were intentional. Two, whether or not the representations concerning the prior medical treatment were directly related to the central issue in the case. And number three, whether or not the trial court conducted an evidentiary hearing. All three of those factors are satisfied here. And really the only possible issue or factor that appellant could argue here is whether or not there was an intent to defraud, because clearly we had a evidentiary hearing. Clearly we have the misrepresentations were directly related to the central issues of the case, which has to do with the causation of her injuries. In her deposition testimony, she testified that her pain, her injuries, and the car accident were her problems with her neck, her lower back, and also her shoulder, and also her head. She was suffering headaches too. So when you go back and look at all those misrepresentations concerning her prior injuries, her two prior auto accidents, neither of which she disclosed. She finally disclosed one of them after she was pressed under oath. And when you take a look at all those other complaints of pain that she failed to disclose, it's pretty clear that there was an intent here. When you take, in fact, taking into consideration all of the evidence together, not just one or two, when you take into consideration all those lies, there's clearly an intent to defraud. I think that taking a look at some of those misrepresentations are important, especially relating to her reaction that she had to the COVID vaccine. There's one particular post that I wanted to point out. It's the October 6, 2021 post, where appellant posted a photograph of her in a hospital gown and hospital hairnet with a caption, "Another day, another something. Today we're taking care of some pain in the back from nerve damage around the spinal cord." And she took that and she's relating that to her bad reaction that she had to the COVID vaccine. So she failed to disclose that in her deposition when she was asked about all of her symptoms that she had relating to her COVID reaction, but yet she's posting online to all of her internet followers, which she claims has to be around 50,000 followers, that she has these conditions, reactions to the COVID vaccine that go directly to her injuries that she is claiming in this case, which is her back and neck injuries. So those clearly go to the central issue in the case. Also, and I don't want to take a lot of the court's time going through every single misrepresentation, and I've counted so far just through my notes preparing for the oral argument today. There's about 14 or 15 direct misrepresentations that she lied, where there's clear evidence where that's not the case if you look in the medical notes. But also, I think it's important that one of the posts, she also says, "All of my symptoms and diagnosis are a result from that," meaning the COVID vaccination, because that's my only contributing factor. That's what she says in her social media posts that she sent out to her 50,000 followers. But yet she gave a completely different story under oath. Just looking at my notes here. I think that sums it up. Unless the court has any other questions, I'll conclude my presentation. I would ask the court to affirm the order under review. Thank you.
Thank you, Mr. Irvin. Mr. Ellis, are you there? There you are.
Sorry.
You're good. All right.
I'm sorry. I'm just setting a timer, Your Honors, for myself.
Okay. Cool.
May it please the court. So everything that we just heard sounded like a cross-examination. And that's what should have happened. I mean, it's a fundamental philosophical difference. Does it cross the line into fraud on the court? Or is it just, as this court said in Synergy Contracting, and many other courts have said, even lying is best resolved through cross-examination. And we're not conceding that these are lies. As the record shows and as the briefing shows, there are answers for many of these putatively false statements, not the least of which is the fact that nothing said on social media can constitute fraud on the court. And yet the trial court simply credited all of that online content as true and the in-court content as false. Respectfully, that was not a judicial determination to be made, but rather a jury determination to be made. And to the extent that opposing counsel has argued just now, Ms. Galvin would have had to perjure herself in order to testify. Again, that's simply presupposing that all the social media statements were true and anything putatively conflicting with that was false. That's a jury question. The idea that this argument that just because the defense counsel discovered some of this information does not negate fraud on the court that's, I don't want to say a straw man argument, but we disclosed a lot of what was alleged to be not disclosed. So as trial counsel below noted during the evidentiary hearing for Ms. Galvin, it's hard to conceive of a scheme of fraud on the court where there are disclosures made. And just to give an idea, although we don't have to go through each of the putatively false statements, but one of them is literally that Ms. Galvin forgot to disclose a doctor's appointment she had when she was an 18-year-old with her mother, which happened 20 years ago. That can't be fraud on the court, especially not where the operative pleading alleges that this accident may have exacerbated pre-existing injuries. She didn't come in here saying that this was a clean slate. She said she had a long, extensive medical history from the very beginning of this lawsuit. And so it is not something that warrants dismissing the entire lawsuit, even if we're going to assume defense counsel is right about a lot of this. And so kind of more broadly, where to draw the line invokes Judge Altenburn's concurrence in Ramey versus Haverty, in which Judge Altenburn stated that he questioned whether appellate courts have yet fashioned the appropriate test or guidelines for determining where to draw the line between this is cross and this is fraud on the court. And again, we believe that the 5th DCA's decision in Jimenez versus Ortega, the 4th DCA's decision in Goga versus Public Supermarkets, and then this court's precedent in Duarte versus Snap-on, as well as Jacob versus Henderson, show where there is undisputed liability, you cannot dismiss the entire action for fraud on the court because you are doing something that, quotes, kills it all, to use the trial court's words. Instead, it would be incumbent on the defense to prove, almost like a motion for partial summary judgment, what aspects of damages were tainted irreparably by these non-disclosures. That's what the 5th DCA did in Jimenez versus Ortega when it affirmed in part and reversed in part and said that, sure, those portions of the claim for which there's fraud on the court, dismiss those, but where there is undisputed liability and no serious argument that the plaintiff was not injured, you can't dismiss that. And it's important to understand why liability is undisputed. Because in June of 2020, in this case, Ms. Galvin was driving her car when an Advance Auto Parts store van going 35 miles an hour cruised through a red light, did not apply its brakes, and T-boned Ms. Galvin's car. It's on video. There's no way to dispute liability. So instead, the defense has done what they have to do, understandably, and attack causation and damages. But what they can't do is throw out the entire case after admitting liability. That's not our argument. That argument is based on this court's precedent in Duarte and Jacob. And so we respectfully request that this court reverse, because any inconsistency should have been handled through cross. Thank you.
Thank you both very much. In order to leave our virtual courtroom, you need to click the button in the lower right-hand corner of your Zoom screen. It'll either just say leave, or it might have a pictograph of a person going through a door. You click that and you're off into the ether.
Thank you, Your Honors.
Thank you. Have a good day.
You too. And with that, we're adjourned.